When you collaborate with others on a creative work, you might be creating a joint work. U.S. copyright law defines a joint work as a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. In this video, we'll break down that definition, discuss what it means to be a joint author, and review how you can register a joint work with the U.S. Copyright Office. First, let's look at the elements of a joint work. A joint work must have two or more authors contributing to it, making them joint authors. Additionally, those authors must intend to merge their contributions into a combined single work. That means when the authors created their contributions, they planned to combine them into an integrated whole. There should be an agreement or other indication that all authors were clear about those intentions. For example, Maria just finished writing her novel. Her publishing company decided it would be even better with cover illustrations and hires Amy to create the visual art for Maria's book cover. The resulting book, however, is not a joint work because Maria did not intend to merge her story with Amy's illustrations when she wrote it. Later, after seeing success with the first book, Maria and Amy collaborate on a graphic novel and, from the start, plan to combine Maria's text and Amy's illustrations into the final product. Because Maria and Amy intend to merge their contributions into an interdependent unitary whole, this second book is a joint work, and they are joint authors. To become a joint author, the office takes the position that each author of a joint work must contribute a sufficient amount of original authorship, meaning copyright could protect the individual contribution on its own. For example, Joe, Stacy, and Tom are members of a band figuring out the concept for their next song. Their friend Dylan suggests an idea for a song about cats. This inspires the band, and while Joe and Stacy work on the melody, Tom writes the lyrics which incorporate Dylan's idea. But Dylan is not a joint author. Even though his idea inspired Joe, Stacy, and Tom's completed song, Dylan did not contribute copyrightable content because copyright law does not protect ideas. Instead, if Dylan helped Tom write the song's lyrics, contributing sufficiently creative content, and all of them intend to merge Dylan's written contributions into the work, then Dylan would be a joint author. With joint works, all authors are co-owners of the copyright, and each owner has the right to exercise any of the exclusive rights specified in the Copyright Act. Any owner can also authorize others to use the work in one of these ways, but they must share any royalties with all of the copyright owners unless there is an agreement otherwise. Copyright protection begins the moment you create the joint work in a fixed form and lasts for 70 years after the death of the last surviving author. Although not required, registering your work with the U.S. Copyright Office gives you important benefits, such as creating a public record of your ownership. Timely registration may also give you the ability to seek certain remedies in cases of infringement. Registering your work or receiving a refusal to register is required to bring an infringement claim for a U.S. work. To apply for registration, one of the copyright owners must submit a completed application form, a non-refundable filing fee, and a non-returnable copy or copies of the work known as a deposit. Only certain types of application forms can be used, and the party who submits the application must be sure to include the names of each author who contributed copyrightable authorship to the joint work. To learn more about registration and the types of applications available, visit copyright.gov. And for more information about some of the copyright concepts mentioned in this video, check out the rest of our Learning Engine series.